All right, we are joined now by Stuart Zuckerman with Zuckerman Law, who's here to bust some common divorce myths. Thanks for being here.
Happy to be here.
So a lot of people tend to get advice from their friends or family, and as you've told us many times, that is not often the best advice. So let's go over some of these common questions that you get from people. Is it true that if a house is in someone's name, they can force their spouse to leave or get a greater share of the house?
That's not true. That's a common myth. So it doesn't really matter whose name the house is registered in. Both parties in either a marriage or in a common law relationship where you've been with us in a spousal-like relationship for 2 years or more, you have the right to occupy the home, and you also have a right to share in the growth and equity in the home from the date that you began cohabitation to the date that you separate. The party who owned the home first gets to keep the equity that they had on the day before cohabitation, but all the growth in equity and also growth in debts from the date of cohabitation forward are shared.
That would be shared. Okay, another common question you get, if someone is in a common law relationship and never married their spouse, are they entitled to less than they would be if they were in fact married?
No, under the BC Family Law Act, which came into force in 2013, whether you're a common law spouse or whether you're married, you have the exact same property rights.
Right.
Prior to 2013, the law was quite different, but since that act came into effect, all common law spouses have the same rights of married spouses, both to the growth in equity, the growth in debts being shared, and also claims to alimony or spousal support.
And that's after a 2-year common law relationship.
That's correct.
Okay, the third one is whether the courts favor the wife over the man in a spousal relationship when it comes to parenting.
That's, again, a common myth. The court's focus is on the best interests of the children. So when it comes to parenting after parties separate, the courts do look at the historical childcare relationship that existed up to the date of separation.
Right.
So what often happens if mom was a stay-at-home mom and the one bringing the child to school and picking the child up from school while dad was working 5 days a week, then of course mom tends to be in a better position to continue in that role as primary caregiver after separation.
Right.
But if if dad was the person who played that role, then post-separation dad would be in a primary caregiver situation. The court always focuses on the best interest of the child and does try to maximize contact with both parents. So it's quite common. We often go to court and get 50-50 arrangements in terms of the sharing of the children.
Okay.
But the prior care arrangement does have an impact.
Okay, good to know. People often ask you about prenuptial cohabitation and marriage agreements and the fact that they might not be worth the paper they're written on. Is that true?
That's definitely a myth, especially under the new act. If both parties had independent legal advice when they negotiated a cohab agreement or a marriage agreement or a separation agreement, and as long as both parties made full and frank financial disclosure, so as long as you don't lie about your finances when you enter into the agreement, then the courts do uphold those agreements. There are certain common law principles in contract law that you can attack agreements, such as a lack of mental competency to enter the agreement or undue influence, something of that nature, duress. I have gone to court in 3 separate cases where I have set aside either prenuptial agreements or marriage agreements.
Okay.
But in most of those cases, either there was a lack of independent legal advice for the party that signed it, or one of the parties lied about their finances when they entered the agreement. Those are bases to challenge the agreement.
That will do it. Okay, so if you cohabit with someone for 2 or more years, are you entitled to 50% of their assets?
That's basically the way it works. That
Okay.
once you become a common law spouse, that is, you live in a marriage-like relationship for 2 or more years, then the parties share the growth in equity 50-50, and they share the growth in debt 50-50, and similarly, the right to spousal support arises once you've been together for 2 years or more.
Not many people realize that, do they?
It's true. I had a case where a woman in Vancouver owned a home for many years. She then had a renter. A fellow came in as a renter. They then got into a relationship, and they were in a spousal-like relationship for 12 years. They had 2 children, 2 daughters together.
Wow.
When they separated, and I acted for the man, and we went to court and sued, her documents that she filed in response to the suit was that he was a renter. He wasn't a spouse. And she argued that he wasn't entitled to anything. And
You're like,
I got
no,
him
no, no.
over $150,000. So,
Wow.
you know, you are entitled to that growth and equity.
Okay, we have time for one more quick one here. If parents gift money to their children to buy a home and they subsequently separate, then can the parents get their money back when they sell the house before proceeds are divided 50-50?
Usually not, unless
Okay.
that gift is documented as a loan and or registered on title of the home. If you document it as a loan and both parties sign it, so both the husband and wife know and acknowledge they're taking a loan from their in-laws or their parents, or they register it on title, then no problem, that money can be paid back. But if it's a gift to one spouse, for example, and then that spouse puts it into a home in the joint names of the parties, usually it loses its identity as a gift, and you don't get that money back. There are certain circumstances where through gift or inheritance, if you keep assets only in your own name, or it's clearly understood or written that the parties agree that that gift is going to be kept separate if they separate in the future, then you can preserve that gift. But in most instances, you can't go back in time and say that money our parents gave us was a loan and we need to pay it back to them. That happens all the time in family law, and the courts say it needs to be documented if it was a loan.
Okay, Stuart Zuckerman with Zuckerman Law, thank you very much for busting those common myths about divorce. Appreciate it.